The hearing on the Subcommittee on Health, Employment, Labor, and Pensions will come to order. I note that a quorum is present. Without objection, the chair is authorized to call a recess at any time. Thank you to my fellow subcommittee members for coming together to examine the National Labor Relations Board under the leadership of Chairman Lauren McFerrin, who President Biden recently renominated to the board. Thank you to the witnesses for joining us as well, and I look forward to your testimony. Chairman McFerrin assumed leadership of the NLRB the very day that President Biden took office. Under her watch, the NLRB has undergone a shocking transformation. Once a fair and balanced arbiter of labor law consistent with the National Labor Relations Act, or the NLRA, the NLRB has become the action arm for big labor. But big labor bias is a losing strategy for the country. Big labor bias is harmful to companies, employees, and ultimately consumers. After 3 years of this NLRB's decision-making, the typical American worker is far worse off. Real wages are decreasing, and workers' paychecks are stretched more than ever. Average workers' prospects for realizing the American dream of homeownership are disappearing. Workers watched President Biden promise to make sure the economy works for everyone in his State of the Union address back in March. But Bidenomics only seems to work for unions and union bosses. The American working class knows that unions are a tired, outdated remnant of yesteryear. It's no wonder that some pundits and pollsters are predicting the GOP may actually carry the union vote this November. That's because workers' lives are worse off after 3 years of President Biden. The last thing they need is for their paycheck to be docked by a union that doesn't represent their interests. In fact, 94% of workers didn't vote for their current union representation, and recent NLRB board decisions could drive that number even higher. Today, we will discuss a few of the board's key decisions that have led to the place where we are today. The Lion Elastomers LLC 2 decision expanded protections for union-backed workplace harassment, further eroding trust and cohesion between employees and employers. Under the new standard, it's harder for employers to discipline workers who act inappropriately while engaging in union activity, even if that same behavior in another workplace setting would have consequences. Similarly, the 2023 Stericycle Incorporated decision limits employers' rights to maintain neutral workplace rules. The decision's interpretation of Section 7 of the NLRA hampers employers' ability to protect their business and maintain order. The NLRB has made significant strides towards undermining fair union elections. In November 2022, the NLRB proposed rescinding a Trump-era rule that ensured transparency and fairness in union elections. Among other things, it allowed for the release of vote tallies rather than impounding ballots during litigation over blocking charges. Perhaps the most troubling is the 2023 CMEX Construction Materials Pacific Division, which fundamentally alters the union recognition process. It permits unions to demand recognition from employers based on a claim of majority support, thereby bypassing the secret ballot election process. This decision removes the democratic element of in-person secret ballot elections, replacing them with coercive measures that pressure employers into union recognition without proper verification. Under Chairman McFerrin's leadership, the board has engaged in gross mismanagement in the conduct of mail ballot elections, according to an October 2023 report from the NLRB Inspector General. Furthermore, an investigation conducted by this committee revealed numerous findings of similar mismanagement in the administration of mail ballot elections across the country. It's a testament to how radical this board is, as it ignores its clear legal duties to manage fair elections in favor of overturning decades of precedent. Rather than take ownership of this mismanagement, the NLRB under Chairman McFerrin has yet to comment publicly on the mismanagement of mail ballot elections. And despite this committee's request, it's unknown whether the board has sought to fix these problems internally. Exposing and highlighting, or lowlighting, the board's mismanagement and undermining of key principles of the NLRA is the primary objective of this hearing. It also raises the question of whether Chairman McFerrin should be renominated, a question the Senate should answer by holding a confirmation hearing. Thank you, and I yield to the ranking member for his opening statement.
Thank you, Mr. Chairman. As I have repeated many times, as many of you know, I was a small business owner for over 30 years. I pride myself in the relationships that I had with my purveyors and my customers and my employees over those 30 years. I understood that my success as an employer, having met multiple pay responsibilities to my employees, was part of my success. That good employees and good employers work together for the success of the company, whether it's a privately held company or a corporation. I learned clearly in those 30 years that there was an absolute obligation for your success and your return on investment and your profitability to make sure that your employees were well treated. And if employees didn't perform, just like employers and managers, you would hold them accountable. And as a former union member, I know firsthand the benefits of union membership and the power workers' unions have to bridge the gap between workers and their employers to help not only union workers succeed, but all workers. After all, it was a labor movement that built the middle class in the United States by giving employees a voice on the job. And some of our nation's greatest advances for workers, from the 5-day work week to the minimum wage to child labor laws, have been made possible by the labor movement. Americans recognize the importance of unions, which is why over 2/3 support of approval or have approval of labor unions. Not only is public support at a near record high, more and more workers are uniting to demand higher wages, improved benefits, safer workplaces, and we should support them. And those employees work with their employers for their success and for the consumers' and investors' success. As Galbraith put it, labor unions are among the countervailing powers to balance capitalist markets and the interest of corporations. I look forward to this subcommittee and my Republican colleagues having a similar hearing on abuses on the Security Exchange Commission under the former administration in the favor of very wealthy people. Recently, I read that 751 Americans now have $5 trillion worth of wealth. All of that came from middle-class incomes, or much of it, not that just their investment strategies. Today's hearing appears to be focused on the National Relations Board, which during the Biden administration, under Chair McFerrin's leadership, has often reinstated common self and longstanding precedent that was cast aside by prior administrations' boards. In the process of doing so, the NLRB has restored balance between workers and their employers. Not an advantage, but balance. I look forward to discussing those cases today and setting the record straight on them. In spite of our differences, I think all of us want a balanced economy that all Americans benefit from, I think. The bottom line is that Chair McFerrin deserves credit for her leadership and thoughtful approach on balance. President Biden recently recommended her for another 4-year term, and I encourage the Senate to again confirm Ms. McFerrin, just as they did on a bipartisan basis in July of 2020. But I think today's hearing presents an opportunity to hear about how the board really functions and carries out its duties. We are fortunate to have, as one of our witnesses, a Democratic witness, Eileen Goldsmith, a partner in a San Francisco law firm for more than 20 years. Ms. Goldsmith has represented clients who regularly appear before the board in both unfair labor practice and representation cases. She understands how the board works and is supposed to work. She's great to have someone from my neck of the woods, the San Francisco Bay Area, to testify before this subcommittee, and welcome. Thank you for making this trip to DC and sharing your expertise. What I think is clear that Ms. Goldsmith's testimony is that the board carries out its duties often on a bipartisan basis, but the board needs additional resources to function effectively for workers and employers and the American public. My Democratic colleagues and I strongly support additional funding for the NLRB to ensure that it can manage its caseload. But as Ms. Goldsmith's testimony makes clear, it is not just resources. Unscrupulous employers can get away with firing workers who try to organize a union. Congress needs to step in and stop that from happening, both for the employees' benefit, but also for high-road employers who follow the letter of the law and the spirit. And that's why we need to pass the Protecting Right to Organize Act, the PRO Act, and continue to uphold our commitment to workers' rights, which are all Americans' rights. Thank you, and I yield back.
Thank you. Pursuant to Committee Rule 8C, all members who wish to insert written statements into the record may do so by submitting them to the committee clerk electronically in Microsoft Word format by 5 p.m. 14 days after the date of this hearing, which is June 26, 2024. Without objection, the hearing record will remain open for 14 days to allow such statements and other extraneous materials referenced during the hearing to be submitted for the official hearing record. I'll now turn to the introduction of our distinguished witnesses. Our first witness is Mr. John Ring, who's a partner with Morgan Lewis in Washington, D.C. He previously served as NLRB chairman from 2018 to 2021. Welcome, Mr. Ring. Our next witness is Ms. Alice Stock, who's of counsel with Bond, Schoeneck & King in New York. She previously served as the NLRB Deputy General Counsel from 2019 to 2021. Thank you, Ms. Stock. Our third witness is Ms. Eileen Goldsmith, who's a partner with Altshuler, Berzon in San Francisco, California. Her practice consists primarily of representing unions and workers. Welcome, Ms. Goldsmith. And our final witness is Mr. Douglas Seaton, who is President and General Counsel of Upper Midwest Law Center in Minneapolis. He's long practiced labor and employment law. Welcome, Mr. Seaton. We thank the witnesses for being here today. We look forward to your oral testimony. Pursuant to committee rules, we'd ask that you limit your oral presentation to a 5-minute summary of your written statement. And I'd like to remind the witnesses to be aware of their responsibility to provide accurate information to the subcommittee. And we'll now recognize Mr. Ring for 5 minutes.
Thank you, Mr. Chairman. Chairman Good, our ranking member Desanya, and other subcommittee members, thank you for your invitation to participate in today's hearing. As mentioned, I am a partner at Morgan Lewis, where I practice labor law and did so for almost 30 years prior to becoming chairman of the National Labor Relations Board. I served as chairman for almost 3 years and then as a board member until the end of my term in December of 2022. Although I've spent my career representing management, I am proud to have started in the labor field working at the Teamsters headquarters here in Washington. Is an experience that gave me an important perspective and that shaped my overall approach to labor relations. I'm a firm believer that labor law works best when both sides play by the same set of rules and understand and respect each other's objectives. We're here today to talk about the National Labor Relations Board, an agency that I care a great deal about, and about the National Labor Relations Act, a carefully crafted statute that for the last almost 90 years has done an admirable job of balancing the interests of labor and management. While the NLRB over the years has largely fulfilled its central objectives of promoting workplace democracy and ensuring industrial peace, I fear today the NLRB has seriously lost its way. The current Biden board majority and the NLRB General Counsel are promoting a particular agenda and attempting to administratively rewrite the act. They are doing this to facilitate unionization and to increase union density at the expense of individual employee rights and employer interests, despite the fact that the act clearly directs the agency to be impartial and be an impartial arbiter of labor matters. Approximately 8 years ago, many had similar concerns about the NLRB. The Obama-era board had started a process of overturning years of longstanding case precedent in many areas of established board law. At the time, many were alarmed at what was happening. It appeared to be a blatant attempt to rewrite key aspects of the act and also an upsetting of the balance established by the National Labor Relations Act, tilting it towards labor. At the time, the board was also bogged down and distracted with many of these efforts that seemed to be focused on non-core priorities. I was very concerned, and it's one of the reasons I feel fortunate that I was able to have an opportunity to serve on the National Labor Relations Board. While I was chairman, we were able to restore the board's historic balance, and we reestablished much of the decades-old precedent that had been changed during the Obama years. We returned many of the standards to what they had been for decades, including the joint employer standard, the independent contractor standard, and the rules governing union election procedures. We also worked to reduce an appalling case backlog, and we did so largely by putting an end to the Obama board's pursuit of these issues that were outside of the core mission, or that involved dubious statutory interpretations that resulted in lengthy, unsuccessful litigation. After the Obama-era board, we thought we had seen the worst at the NLRB. Unfortunately, the current board majority appears to be reverting to, and in fact, doubling down on, the old game plan. Today, we find ourselves in a back to the future moment, although what is happening now is far worse. From their outset in the time in office, the new board majority and general counsel have made no secret that their intent is to undertake a wholesale rewriting of the act. They immediately targeted precedent that we had restored, called for unprecedented expansion of many interpretations of the act, and are now steadily working to remake and reimagine the National Labor Relations Act into something the drafters of the statute never intended or could have imagined. And in doing so, both the board and the general counsel are again pursuing issues that are either outside the core mission or involve suspect statutory interpretations that are being rejected by the courts. Among the most troubling of these areas is the current board majority has radically upended the framework for union organizing, and under the new CMEX case, there's essentially compulsory unionism simply because a union says it represents a majority. The board now imposes unionization on employees through mandatory bargaining orders based solely on their conduct of their employer, and despite the fact that Congress rejected card check repeatedly, there's now card check in the NLRB process. I'll end my statement by saying no one claims the NLRA is perfect, but at times both labor and management have suggested otherwise in some amendments. But in the end, it's Congress that makes the federal labor law, not the NLRB. Thank you.
Mr. Ring. We'll now recognize Ms. Stock for 5 minutes.
Thank you for the invitation to testify at this hearing. I'm honored to be here. I've been asked to assess the board's performance with respect to protecting workers' rights and fairness. In my opinion, this board's decisions, policies, and management of agency operations are inconsistent with and contrary to the mission and core principles of the NLRA. Indeed, the current board agenda subverts the aims of the NLRA and impedes its utility and effectiveness as a constructive contributing component of our nation's labor stability. This board's policies disregard balance, fairness, and the rights of employees and employers, and negate its role as an impartial administrator of the NLRA and guardian of workers' rights. This board's agenda is neither neutral nor fair. It is an agenda that favors unions and tramples the rights of workers and employers. Its rulings violate constitutional principles, usurp the powers of Congress, contradict U.S. Supreme Court holdings, lay waste to the rules of administrative procedure, and trample the substantive and procedural due process rights of employees and employers. The NLRB's two functions are to conduct secret ballot elections and to investigate and resolve labor disputes through settlement or board decision. In performing these two functions, the board must conform to the U.S. Constitution and applicable U.S. Supreme Court rulings, adhere to the NLRA's text, and may not make or change the law through decision-making, and act neutrally, impartially, and even-handedly, favoring neither employers nor unions. This board's decisions and policies do not hew to any of these cardinal principles. I address three areas of grave concern. Elections. This board's decisions, policies, and practices concerning representation elections have and are, practically speaking, disenfranchising large numbers of workers and deliberately depriving workers of their right to vote in a secret ballot election. Contrary to NLRA principles, this board is imposing on employees unelected bargaining representatives that likely or actually do not enjoy majority support. This board's preference for mail ballot elections over in-person elections and its mishandling of mail ballot elections also disenfranchises employees because they result in reduced voter participation, increased invalidation of ballots, and greater employee exposure to union coercion and intimidation. Decision-making. In its adjudications, the board has not colored within the lines of the law and congressional intent, but instead has radically changed the law. The board's decisions exhibit a troubling disregard for the core principles of the NLRA, for its obligation to follow applicable U.S. Supreme Court precedent, for the rights of employees and employers, and for substantive and procedural due process. Caseload mismanagement. Case processing times and backlogs have increased at all levels of the NLRB during periods of decrease or no tangible increase in case filings. These backlog increases can only be attributed to mismanagement by agency officials. Enshrined as a core principle of the NLRA, and indeed of our democracy itself, is the selection of a representative through a secret ballot election. The secret ballot election has been the gold standard for selecting bargaining representatives since 1935. This board has nevertheless pursued an anti-democratic policy agenda to eliminate secret ballot elections, thereby depriving employees of the free choice and selection of a bargaining representative that is guaranteed by the NLRA. In its zeal to push its policy agenda and rewrite the text of the NLRA, this board has ignored the bedrock concepts of our legal system: fairness and due process. The board's decision-making and mismanagement of elections and agency caseload negatively impact the effectiveness of the NLRB and undermine its authority and credibility as a neutral arbiter of labor disputes. They also subvert the purposes of the NLRA and endanger its utility and effectiveness as a source of labor stability and a pillar of economic growth of our nation.
Time has expired. I'm sorry. Thank you very much, Ms. Stock. Ms. Goldsmith is recognized for 5 minutes.
Thank you, Chairman Good. Thank you, Chairman Good, and Member Desaulnier, members of the subcommittee, for the opportunity to testify today. I am a practicing union lawyer in San Francisco. I've been representing labor unions for more than 20 years, and I want to bring the focus to what does this agency actually do from the perspective of someone who practices regularly before the agency representing clients. What does the board do? The board's central duty is to protect employees' rights under the Act in Section 7. And I think it's worth looking at the language of Section 7 for just a moment. It creates the right to self-organization, to form, join, or assist labor organizations, to bargain collectively through representatives of their own choosing, and to engage in other concerted activities for the purpose of collective bargaining or other mutual aid or protection. And it also, the Act also protects employees' right to refrain from those activities. In upholding the constitutionality of the Act, the U.S. Supreme Court in Jones and Laughlin Steel called those Section 7 rights a fundamental right. So that's the right we're talking about. That is what the board is interpreting every day. And I have the greatest respect for the Act and the rights that it created. In my testimony, I talked about typical examples of how the board operates, almost always in a very nonpartisan and unanimous fashion. And particularly when you look at cases down at the regional level, which is where the overwhelming majority of cases are actually resolved, they are resolved in a thorough, professional, and utterly nonpartisan way. I wanted to mention a couple of cases that kind of illustrate both what is the ordinary functioning of the board and what workers are up against when they attempt to exercise their Section 7 rights. And these few cases that I mentioned in my testimony from my own law firm, one is, and generally speaking, these cases are involve the application of well-settled law to sets of facts, and they may not be grabbing headlines, but these are crucial functions of the board that workers and their representatives rely on, as well as employers. In one typical case that my colleagues handled in my firm, several workers who were employed by a construction contractor were fired when they tried to organize a union. After a union organizer met with workers at the job site, the workers followed up with that organizer, met with him, discussed unionizing, and signed authorization cards. The very next day, a supervisor told one of the workers that he, quote, knew what you guys did with the union yesterday, unquote, and directed one of those workers to fire the others because, again quoting, the company does not use those type of people. A supervisor confirmed later that day that all of the workers had been fired. The union filed a charge against this company for alleging that the company fired those workers for having tried to unionize. And following a thorough investigation by staff at NLRB Region 21, the board's general counsel found probable cause to believe the employer violated the act. The case proceeded to a hearing, and I can't say it any better than the ALJ said it. The motive for the workers' firings, best supported by the record, is that the company hoped that by terminating a handful of employees, including some relatively senior and influential ones, it could quell interest in a nascent union campaign. And as the data shows that I discuss in my written testimony, what happened at that company is hardly isolated. The other point I'd like to raise briefly is elections. My firm has recently handled several elections involving Stanford Healthcare and Packard Children's Hospital. In each case, the union and the employer stipulated to the proposed bargaining units and the terms of those elections, so the employer agreed to handle those by mail ballot. They went very smoothly. They had very high participation by the voters, 79 to 100% participation. And we were very grateful for the efficiency and professionalism of Region 32 staff in handling those matters. Despite the NLRB's important work, a critical problem that confronts both labor and management is the severe understaffing at the board and the budget, which was flatlined for almost a decade until a slight increase in fiscal year 23. That is not good for anyone.
I'm sorry, the time has expired. Thank you, Ms. Goldsmith, and we'll finally recognize Mr. Seaton for 5 minutes.
Thank you, Mr. Chairman, Ranking Member DeSagne, members of the committee. You have a full bio and the written testimony I've provided in much more detail than I can review here, of course, today. But my background is simply that I've taught and practiced and written about labor history, labor law, labor relations for 40-plus years. I now work for a nonprofit, nonpartisan public interest law firm, but I'm speaking here simply as an individual because of my concern about the status of the National Labor Relations Board's deliberations and the functioning of our labor relations system, a great institution in our country. I believe that Senators Wagner and Taft and Representative Hartley, the authors of our labor laws, would not recognize the direction of the NLRB under the current chair. The genius of the American labor law system is in several respects contrasting with that of other major democracies and those influenced by Western democracy. We have three critical things going for us in our system. One, our employees choose union representation or not, and can extricate themselves from that representation if they wish to do so. That's important, and it's unique. Second, we have a system based on single employer bargaining, not national accords, not national strikes over political and social issues, but individual employer agreements, which is a very, very important thing for our system. The third piece is we have a tripartite balanced system which recognizes employee rights, union rights, and employer rights. And that's a system of checks and balances that's very familiar to the members of this subcommittee. It's the same one we have functioning in our Constitution nationally. Those are important things to preserve. It's a balanced system with employee choice at its center, and it functions by returning to equilibrium whenever one group overreaches, gets out over its skis. But when one of the parties involved, or even worse, the agency itself, puts a thumb on the scales, that is not good for the system. It doesn't work in anyone's interest, and it doesn't work in the country's interests. I have grave concerns that the current board, under its current chair, is not adhering to the spirit and purpose of the NLRA as I've described it in several of its recent decisions and actions. The clear pro-union institutional bias of the current board chair and corresponding anti-employee and anti-employer animus are particularly disturbing because, as this subcommittee knows, unions represent only 6% of our workforce in the private sector, 6% of the workforce, and even less when you consider the large number of service providers who function as independent contractors, choosing not to be employees themselves. Now, as time allows, I'll mention a few specific areas of concern which I have over the current board. There are 6 in number. I'll try to be very brief for the committee's pleasure. Employee free choice. Everyone at this table has mentioned that free choice. That's a choice that extends to either selecting or unselecting union representation. I believe that the current NLRB has modified, sought to overrule, or has changed decisional law and procedures in many areas to limit the ability of employees to have that choice that the labor laws are meant to enshrine in our country. And that's a very serious problem in our system at present. The second area I'd mention is employee protection from insults in the workplace. The current board has allowed unions and individual employees to insult one another in the course of union activity. That was not allowed under the prior board, and employers were permitted to discipline in those cases when those things happen. That's been disallowed at present. The third area I'd mention is employee confidentiality protections in complaint investigations. This is a central feature of employer practice recommended by the EOC and state discrimination agencies and whistleblower areas and other areas. But the current board has allowed unions and itself to intervene in the confidentiality process, which hurts employees, allows retaliation against them, and imperils the integrity of those investigations as well. Fourth area I'd mention, because it's very critical to employee choice, is employer-run meetings to instruct and teach about labor law and labor relations process. This is extremely important, and the result of it is this board has simply disallowed, is in the process of disallowing these meetings, which have been going on for many, many decades. So we are now in a position where employee choice is offended in many areas. And I'll stop there. There's more, of course, in my written testimony. I thank the committee very much for its opportunity to speak here today.
Thank you. Under committee rule number 9, we will now question witnesses under the 5-minute rule. I now recognize myself for the purpose of questions for 5 minutes. The National Labor Relations Board was created by Congress to serve as a fair and neutral mediator to help resolve workplace disputes between employers and employees. The Biden administration has used the NLRB as a tool instead of for employees for big labor interests. In May of 2023, the NLRB issued a decision in the Lyon Elastomers LLC case that restores the board's setting specific standard for determining whether an employee's abusive conduct is protected by the NLRA. The decision will make it very difficult to discipline workers for offensive or abusive conduct while engaging in quote-unquote protected activity under the NLRA. The board held that to fully protect employee rights, conduct during protected concerted activity must be evaluated in the context of that important activity, not as if it occurred in the ordinary workplace context. Marvin Kaplan dissented from the decision, highlighting that it would create significant conflict between the board law and equal opportunity laws prohibiting discrimination, workforce, and harassment issues. So my first question is for Mr. Ring. As being the former chairman of the NLRB, I understand that you formerly served and And so you might have some insight on the decision, the Lion Elastomers case, which would, I believe, create potentially opportunities for people to make racially offensive, discriminatory, or sexually offensive statements or otherwise at work without repercussion. Can you discuss how this creates a direct conflict between the NLRA and Title VII of the Human Rights Act, Civil Rights Act?
Yes, thank you, Congressman. The NLRA, or the NLRB, for some reason, as you mentioned, believes that employees who engage in union activity or other kind of labor relations activity have to use, or should be permitted to use, offensive conduct and offensive speech. When I was chairman, we overturned those setting specific standards in a case called General Motors, and then the current board reversed again and reinstated Lion Elastomers. Under our civil rights laws, and the EOC has weighed in on this, employers are required to take action when employees are engaging in offensive conduct that could create a hostile work environment. The NLRB then takes the position that that is protected. So it puts employers in the position of having to decide whether to violate the civil rights laws or the EEO laws, or a violation of the National Labor Relations Act. And the conduct that was permitted under this standard is abhorrent.
So in essence, you can be racially, you can discriminate, you can be offensive, you can commit sexual harassment, so long as you are organizing.
Or worse than that, as long as you are mentioning wages, hours, or working conditions while you're talking about that.
Thank you. Mr. Seaton, the NLRB issued decisions to limit the circumstances and times when employees can decertify or change union representation. Can you discuss how this has made it more difficult for workers and eliminated their choice whether or not to withdraw from a union?
Yes, thank you, Mr. Chairman. Yes, a core principle, of course, as everyone at the table has said before the committee, is employee choice. Part of the choice is a choice to end union representation, and that's the decertification election process. That process has been truncated under the current board chair so that in prior circumstances where this had been available at the sale of a business in many cases, at the termination of a collective bargaining agreement, in an impasse situation, or simply when the employees chose to do so, when a contract wasn't in effect, the board has truncated this right and has typically undermined the decision the employees have made in many of these instances, saying that somehow the employer is always involved somehow when a decertification takes place. And I think this is a fundamental trampling on the rights of employees to make these choices, and it has been a serious problem under this current chair.
I believe that employees should have the choice to remain in the union or negotiate with their employer without a union representation, which is why I introduced the Workers' Choice Act. I now recognize Mr. Courtney for 5 minutes.
Great, thank you, Mr. Chairman, and thank you for the witnesses for being here. This is our 6th hearing in the 118th Congress on this subcommittee that I would really almost just describe as union bashing. Despite the sort of, talking points that we hear at these hearings, the fact of the matter is, as Mr. Desaulnier mentioned in his outset, the annual Gallup poll still shows that labor is in a far stronger position with the American public than it has maybe 10 or 15 years ago, close to 70% support for unions. Mr. Seaton, thankfully, or I appreciate the fact that I pointed out that in the private sector it's at 6% organization. So the notion that somehow unions are, the deck is stacked right now in terms of organizing and labor law in the U.S. as far as union is concerned, I think those two numbers really suggest otherwise. We've seen 2 very high-profile union elections just in recent months. Where, in my opinion, it really shows that the process is still balanced. We had the Volkswagen plant in Tennessee, where the workers, despite a lot of national pressure and attention that was being put on it, voted to join the union. Conversely, in Alabama, when the Mercedes union election took place, the opposite result occurred, again, under this same NLRB board that, we're hearing so many negative things about. So, Ms. Goldsmith, there was some testimony this morning that, that the right to a secret ballot is being eliminated under the CMEX ruling. Again, sounds like you've been directly involved with some union elections recently. Can you sort of clarify, really what that decision says and the fact that secret ballots are still very much a protected process if the parties so choose?
Sure. The process of voluntary recognition as opposed to a secret ballot election has always been legal under the National Labor Relations Act. An employer can agree voluntarily to recognize a union when the union comes and says, we have majority support among the employees. What the CEMEX decision does is says, when a union presents a request for voluntary recognition based on majority support, the employer has two choices. The employer can either grant voluntary recognition or can file an election petition to verify whether, in fact, the union does have majority support. And the union also still has the ability to file its own election petition. And, in practice on the ground, since CEMEX was decided, that's what we're actually seeing is unions do file those election petitions and or the employer is filing its own election petition. And there are distinct advantages to having certification following an election for the union because that, for example, there's a legal advantage that only flows from certification, which is you have a protected time period to try and negotiate a first contract with the employer. But the notion that CEMEX has somehow eliminated secret ballot elections, I think is frankly absurd and totally inconsistent with what the board said in the case.
So we also just heard about the Lion elastomers case where, again, there's a claim that that ruling is at odds with the civil rights law. Again, Mr. Chairman, for the record, I'd ask to be admitted a letter from a coalition of civil rights organizations actually in support of the elastomers decision, ask that it be made part of the record.
Without objection.
And again, could you comment again on that ruling, which actually was about restoring a 40-year precedent, which I thought some of the witnesses this morning were all about in terms of trying to respect precedent in the National Labor Relations Act?
That's correct. Lion is one of several cases where the current board is actually restoring the law as it was in effect for decades until the Trump board. And what Lion does is say that those Section 7 rights are important, and under lines of cases that were decided up until the time of the Trump board, the board had held that when employees are engaged in protected activity under Section 7, courts and the board recognize that sometimes things get heated. And when a court or a board or the board is considering speech in that context, it has to take into account the Section 7 context.
Great, thank you.
Thank
I
you.
yield back.
Thank you. I now recognize Mr. Allen for 5 minutes.
Thank you, Mr. Chairman. Mr. Ring, in 2023, the National Labor Relations Board issued the Joint Employer Final Rule, which upends the traditional direct and immediate control standard and creates an expansive, vague, and costly standard. In March 2024, a federal district court struck down the rule because it exceeded the NLRB's authority. Also in 2024, the House and Senate passed a Congressional Review Act resolution to nullify the rule. Despite a federal court striking down the rule and Congress expressing its disapproval, the NLRB decided to appeal the court's decision, striking down the joint employer rule. As former NLRB chairman, would a bipartisan and bicameral rejection of a rule along with a court decision knocking the rule down have been taken into consideration when deciding whether to pursue an appeal?
Of course it would. And I'll just add that there was a very similar joint employer standard that was adopted by the board during the Obama years that was struck down by the DC Circuit at least twice. So this standard that they've been pushing is the DOA on a number of courts. Why they continue to push it is puzzling. I always viewed my role at the board as trying to color within the lines. We saw our role as not having a particular agenda, but rather to enforce the statute and interpret the statute the way Congress had written it and is interpreted by the courts. This board does not seem to follow that same approach.
And I'd like to emphasize here that I have a bill, the Employee Rights Act, which clarifies that 2 or more employers must have actual, direct, and immediate control over employees to be considered joint employers, and will protect the franchise model by codifying the long-standing definition to prevent franchise owners from becoming corporate middle managers. Mr. Seaton, during Chairman McFerrin's tenure, the board has revised election rules for union representation and decertification elections to diminish employees' rights to refrain from union activity. Can you discuss some of these basic changes made by this board?
Yes, thank you, Representative. Yes, the changes are many throughout the procedural rule, and they, as I said in the earlier comments I made, they truncate employees' rights in many ways. Now, employees don't have a direct role in elections, but they are important for their rights. And those rules have been modified in a way that makes it very difficult to object to the nature of the unit proposed, essentially nullifies the opportunity to challenge the inclusion or exclusion of certain employees within the bargaining unit. And we have found that in many cases that I've looked at, you simply don't have an opportunity to make your point in these proceedings in a way that will affect the actual outcome. So instead, an election takes place, and a union may in some cases be recognized as the bargaining agent, where employees really have not had a true opportunity to make their voices heard in the matter, nor has the employer, for that matter.
Mm-hmm. Well, let me follow up with this. Independent contractors are not employees under the National Labor Relations Act. In 2023, the NLRB issued a decision in the Atlanta Opera case that made it easier for the board to deem independent contractors to be employees. Your written testimony notes that this decision is another assault on worker choice. Can you explain how the board's efforts to undermine an individual's right to be an independent contractor impacts that worker's choice?
Yes, thank you again, Representative. Employees or service providers, I'll call them generically, have a choice as to whether to be employees or independent contractors. That's a very important right under our Constitution, a livelihood right. And the boards has truncated and restricted the arena of choice for employees by essentially making it very difficult to choose to be an independent contractor. In these decisions and many others, and in efforts to promote the joint employer rule that you mentioned also, it has the effect of cutting off that opportunity for employees. I think it's a fundamental right to choose those things, and I think that this board unfortunately has restricted that right.
Right, thank you. And again, the Employee Rights Act would create consistency and clarity across federal statutes with respect to employee and independent contractor status. The ERA provides essential protections for workers' rights, choices, and freedoms for the record. I have additional questions which I'll submit for the record, and with that, my time is out, and I yield back, Mr.
Thank
Chairman.
you. The chair now recognizes Mrs. Hayes for 5 minutes.
Thank you, and thank you to our witnesses for your testimony today. Last year, 16.2 million workers were represented by a union, with the total number of workers in unions growing by 191,000. However, it's important to keep these numbers in context. The percentage of workers represented by a union in 2023 decreased slightly from 11.3% to 11.2%. This is now the 6th hearing in this subcommittee during the 118th Congress on the topic of unions and the freedom of workers to organize. That is one hearing for every 1% of the private sector workers represented by a union in 2023. The right to organize, collectively bargain, and form a union has been the law for nearly a century. Despite this long-standing precedent, many employers continue to commit unfair labor practices because the benefits of union busting outweigh the penalties for breaking the law. In FY 2023, charges of unfair labor practices were up 10%, and in the first 6 months of FY 24, unfair labor practice charges rose by 7%. Until recently, employers faced no monetary penalty for illegally retaliating against workers for exercising their right to organize and form a union. If a worker was fired for participating in a union drive, they were entitled to back pay following the resolution of a case before the NLRB and could have their job reinstated at that point. But the employer would have to provide the money they would be paying had they not broken the law, but the worker could face additional negative consequences beyond lost wages. Without a source of income or benefits from the employer, a worker may rack up credit card debts, miss rental or mortgage payments, and deal with unexpected medical expenses. In December of 2022, the NLRB issued a decision in Thrive, Inc., allowing the board to seek a make-whole remedy for an affected worker for all direct or forcibly pecuniary harms due to an unfair labor practice. My question is for Ms. Goldsmith. In your experience, when workers can only win back pay after suffering from an unfair labor practice by employers, are they truly made whole?
Thank you for the question. When an employee is fired, let's say, for participating in union organizing, they might get a back pay remedy. It might be years after the fact, long after they've gone on to other jobs, long after they've moved on with their lives. And that back pay remedy will also be reduced based on whatever earnings they've had in the meantime. They can also experience all kinds of other direct losses, such as medical expenses they might have to pay out of pocket because they lost their health insurance when they got fired, or job search expenses that are connected to having been fired. The decision in Thrive acknowledged that all of those are part of making a person whole if they have suffered this kind of injury as a result of the employer's unlawful act. And Thrive, I'll add, just pointed out that those kinds of remedies have long been recognized in many cases decided by the board going back decades, and it just kind of collected them in one place.
Thank you. In your testimony, you mentioned that in FY23, the board recovered almost $57 million in back pay for employees whose rights were violated. While that's an impressive figure, it strikes me as a sign that many unscrupulous employers are willing to just provide back pay to prevent workers from organizing. Will the board's decision in Thrive create a more meaningful deterrent against unfair labor practices, in your opinion?
I think it contributes to being a more effective deterrent. The facts on the ground are that employers are willing to violate the act because the remedies are quite weak, honestly. And the more those remedies can actually act as a deterrent, the better off. Employers are willing to take the chance of violating the act because in the short term, in the facts on the ground, they get the result they want, which is to shut down the union organizing effort.
Thank you. I have one more question, but I only have 10 seconds left, so I'm going to yield back so that my time doesn't expire. Thank you for being here today. I appreciate you.
Thank you. I now recognize Mr. Wahlberg for 5 minutes.
Thank you, Mr. Chairman, and thanks to the panel for being here. So often, when people think about labor policy, they don't think about it in the context of higher education. But as we know, college campuses have seen an uptick in organizing over the past several years, with many labor unions expanding to represent graduate instructors and other campus workers. And that's contributed to additional tension on college campuses, which has been magnified since October 7th. I want to highlight a Wall Street Journal opinion piece from March entitled, "My Union Dues Are Being Used Against Israel." The article details how Jewish graduate students at MIT are being forced to pay into a union that openly supports BDS, also with union representative that has been seen, witnessed by these students taking part in demonstrations calling for the destruction of Israel and making anti-Semitic statements. These MIT graduate students had to file an EEOC complaint arguing the union was discriminating against them based upon their cultural heritage and identity, and had failed to provide a religious accommodation to have their union dues deferred. Carrying on from a previous form of questioning, Mr. Ring, in 2023, the NLRB issued a decision in the Lyon Elastomers case that protects union supporters who make racially offensive, discriminatory, and sexually offensive statements or otherwise engage in offensive conduct. Based on the board's decision, would a union calling for a global intifada and the destruction of Israel, or a worker who makes anti-Semitic tropes against a fellow member be protected speech?
Thank you, Congressman. I don't know the answer to that, but I think Lyon Elastomers case and the board's current stance on this issue would make it much less clear that it's not. I think under board law, those type of things should, and the longstanding board law, those types of things should not be protected by the Act. They're outside of the workplace issues, and they should not be protected. This board has signaled that they're willing to embrace that type of conduct as protected, or speech as protected, as long as it has some relations, they can point to something in the workplace. So if some supervisor at some point in time had made a comment that was perceived as discriminatory, that makes it a workplace issue, and therefore that would be protected. Mm-hmm. So it's a slippery slope. Again,
an interesting division between NLRA and Title VII, which is a huge challenge. What recourse do graduate students currently have if they feel their union dues are being used in a way that unfairly represents them? Is there any recourse? This is the difficulty for union members. There really is not a lot of recourse, and as has been stated here before, the normal recourse is to decide to decertify your union, which is very, very difficult under the current system. From your experience, do you think Congress meant for graduate students to be employees under the National Labor Relations Act? I personally do not. I don't think so either. Mr. Chairman, I'd like to submit for the record a recent report published by the Institute of American Worker highlighting how Chair McFerrin has allowed harassment in the workplace.
Without objection.
Thank you. With that, I yield back.
Okay, we now recognize Mr. Scott for 5 minutes.
Thank you, thank you, Mr. Chairman. Ms. Goldsmith, do workers have a private right of action under the NLRA?
No, they do not.
And what does that mean for their ability to have their rights vindicated?
So laws like Title VII and the FLSA provide private rights of action for individuals. So the individual can take their own case to court, prosecute their case, whatever they allege violated the law, subject to exhaustion under Title VII. Under the National Labor Relations Act, the worker can only bring their complaint to the agency. Agency staff investigates their complaint, decides whether or not to bring that case forward.
And does that change? Does the vigorous nature of the cases depend on the administration?
So down at the regional level, I think it does trickle down to the regional level how how cases are processed and what gets attention. But I will say that at the regional level, the staff are very professional and very thorough, and they work really hard to work up whatever charges are brought to them.
And in that light, can you comment on the staffing level at the NLRB and whether or not they have sufficient resources?
Yeah, what we've seen in recent years is the staff are overwhelmed at the regional level. There's been a very dramatic increase in caseload, and that has not been accompanied by a comparable level of funding, and many regions have lost staff and have not been able to replace them. So that is really causing very difficult delays, particularly in processing the unfair labor practice charge cases.
And can you say why it's critical that the NLRB have all 5 board seats filled?
I think what's critical is that the board should always have a quorum. And what we saw in the late Bush administration and the early time of the Obama administration was that the board actually dropped down to 2 members, which was less than a quorum. And that led to, absolute gridlock. Cases were languishing for a very long time. Those people simply did not have the capacity to process the cases that were before the board at the time. And then the U.S. Supreme Court said that the 2-member board decisions were invalid because the board didn't have a quorum. So I would say that the really important thing is to make sure that the board always has a quorum.
You commented on the insufficiency of penalties for unfair labor practices. Can you also comment as to what the level of penalties are as a deterrent for unfair labor practices?
Well, there are no penalties per se in the Act, which is one of the problems in that the Act doesn't have a lot of deterrent power because it is limited to providing make-whole relief.
And as you indicated, make whole could be nothing if the person got another job.
Right.
And in fact, if they got a good union job, they're probably making more than they were making at the plant they got fired from.
Right. We often see that that workers, once you calculate the interim earnings, their back pay may be really negligible, and an offer of reinstatement maybe a couple of years after a worker was fired, they may not be interested in reinstatement anymore because they have moved on with their lives.
And so what kind of deterrent is provided with that kind of system rather than a penalty that would actually punish unfair labor practices?
Right. It's long been recognized that the remedial structure of the Act as it stands is not an effective deterrent to unfair labor practices. Many employers are just willing to even flagrantly violate the Act because they know that they're going to get what they want in the short term, and there won't be really any serious consequence.
And how often does that happen?
I mentioned some statistics in my written testimony that it happens with alarming frequency in election cases.
Thank you, Mr. Chairman.
Thank you. The chair now recognizes our chairwoman, Dr. Fox, for 5 minutes of inquiry.
Thank you, Mr. Chairman. Mr. Ring, this committee has extensively investigated the NLRB's misconduct and procedural irregularities in the administration of mail ballot elections. During the investigation, one thing became clear: the NLRB consistently failed to administer mail ballot elections properly. On June 7th, the NLRB Inspector General released an audit of NLRB mail ballot elections with similar findings. As former NLRB chairman, what would your response have been to the misconduct and procedural irregularities that have been discovered in the administration of mail ballot elections?
Well, thank you, Chairwoman Fox, and thank you for your leadership when I was chairman. I appreciate it very much. The IG report confirms something I think we've all known, and that is that mail ballot elections are not as reliable as the manual elections that have been held in person, and that's because these mail ballot elections are difficult to administer and susceptible to irregularities. If I were confronted with the IG report and with the work that this committee has done on the irregularities with the manual elections, I would immediately stop mail ballot elections until we figured out what the problem was. During COVID, we had to implement mail ballot elections because we had no choice. That revealed a number of issues with mail ballot elections that this board has been slow to migrate back to the solely using manual elections except in extraordinary circumstances. And I would stop that until we could fix it. And the other thing I would say is, as chairman, I viewed the role as making sure that the public and our stakeholders had confidence in our process. And it's important that the chair, I always thought, made clear to the public what they were doing, how they were going to fix a problem, and that so the public could have confidence in the integrity of the board's processes.
Thank you very much. Ms. Stock, your written testimony notes that it is the NLRB's responsibility to administer the National Labor Relations Act by interpreting the law and, quote, coloring in the lines, end quote, not changing the law. What is an example of Chairman McFerrin's board changing the law rather than merely coloring in the lines?
Thank you, Chairwoman Fox. There are a number of decisions in which this board has done that. Key examples are CEMEX and the Tesla case. In CEMEX, the board created a new rule that effectively eliminates the secret ballot election. The board has essentially amended the text of the NLRA so as to trigger what's called major question doctrine. Under that doctrine, an agency may not make an adjudication or issue a rule that is contrary to or beyond the statute. Only Congress has the authority to make that type of change. Similarly, in its Tesla decision, which was a decision that changed decades-long old rules about the ability of employers to have a uniform policy, the board completely changed the rule and said that any uniform policy that could interfere in any way with an employee's right to display union insignia is unlawful, thus making every facially neutral, non-discriminatory uniform policy unlawful.
Thank you. Mr. Seaton, under Chairman McFerrin's leadership, the board has issued numerous decisions that tip the scales in favor of unions over the rights of employees and employers, as Ms. Stock is alluding to. Can you discuss whether Congress enacted the National Labor Relations Act and created the NLRB to serve labor union interests?
Thank you, Chair Fox. I would say no, that is not what they did. It is only in part what they did. They created a system that's designed to be balanced, to create unity in the country, to avoid industrial turmoil, and to give us a system of checks and balances in which employee rights are central, union rights are recognized, and employer rights are recognized. And I am afraid we've tipped the balance significantly under the current chair in the wrong direction.
Thank you very much. Mr. Chairman, I asked to enter into the record letters from the following organizations highlighting NLRB Chairman McFerrin's disastrous record: the Coalition for a Democratic Workplace, the Institute for the American Worker, and the National Right to Work Committee.
Without objection. The chair, pursuant to previous order, the chair declares the subcommittee in recess, subject to the call of the chair for votes on the House floor. We will reconvene immediately following the last vote of the series. Please return to the hearing as quickly as possible so the committee Until then, the committee stands in recess.
Subcommittee will reconvene and come to order following our recess. I recognize Ms. McBath for 5 minutes.
Well, thank you so much. I appreciate it, Mr. Chair and Ranking Member DeSaulnier, and your staff, and to our witnesses today. Thank you for being with us today. I have read your testimonies. This is the 6th anti-worker hearing held by the majority of this Congress, and we had the 5th just 3 weeks ago. And I'm sure as the surge of successful organizing continues around the country, we will continue to see more efforts to undermine Americans' rights in the workplace. Regardless of what may be said at these hearings or how hostile to unions the majority may be, the first section of the National Labor Relations Act clearly states that it is, and I quote, the policy of the United States to encourage the practice of collective bargaining and freedom of association, end quote. But that's the opposite of what we have seen from the majority of this Congress. Instead, we see efforts to change the status quo, alter the rules, and make it as difficult or uncomfortable as possible for working men and women in this country to exercise their rights. My colleagues claim outreach by the Biden administration, but applauded when former President Trump attempted to issue more anti-worker rules at the National Labor Relations Board than had been issued in the 30 years preceding his time in office. The fact of the matter is that this administration is expanding the role of workers on the job and truly living up to the original intent that Congress had when it comes to collective bargaining. Instead of changing the rules to make it harder for workers to organize and more difficult for companies to voluntarily recognize a union, we should be ensuring that every American can freely exercise their rights in the workplace without the fear of being fired and losing their livelihood. The continued villainization of organized labor before this committee is simply wrong, and it's critically important that we fully fund the National Labor Relations Board, pass the PRO Act, and fight back against these misguided attacks on working families. American families deserve better, and I yield the balance of my time.
Thank you, Ms. McBath. I now recognize myself for 5 minutes. Mr. Seaton, Chair McFerrin's board authored a concerning decision, as I'm sure you know, that protects employees who harass others. The Lyon-Elastomer's decision permits offensive and disrespectful conduct when it's related to union organizing. The Lyon decision restored the setting-specific standard. Can you explain the history behind the standard and what it means?
Thank you, Mr. Chairman. Yes, the standard that's being utilized in this case is one which would permit, I guess what we would call misconduct against other employees on the part of union partisans in the workplace. And within limits, that's an understandable rule. But what has happened in this case with respect to the current chair's activity at the board is that the rule has been extended to the point where insults that are basically sexist, discriminatory, racist, homophobic, those attacks can be permitted if they occur within distance of any union organizing activity. And that standard is, I think, an unfortunate one. It's not one consistent, in my view, with the purpose of the National Labor Relations Act. It runs afoul of Title VII. And it puts employers at risk because they are unable to discipline appropriately in the workplace in situations where they should be able to, and it essentially enables bigots in the workplace.
Yeah, it'll make it harder for employees to discipline their employees for abusive or profane behavior, and it would help foster a hostile work environment, which I think actually that's what union organizers want. They want a hostility towards the employer, towards management, towards the organization, towards the company. That's why it's a very unhealthy thing, I would suggest, generally. The Lyon decision puts the National Labor Relations Act in conflict with civil rights law, like Title VII of Civil Rights Act of 1964, which, as you know, prohibits workplace discrimination based on race, color, religion, sex, national origin. And under this law, employers can be held liable if they permit discriminatory behavior, including harassment. So would you agree then with the premise that federal discrimination law makes an exception for harassment if it's part of union activity? You think that there is an exception for that?
No, I don't believe Title VII creates any such exception. So there is a real conflict here between the agencies and the statutes. And I think in this case, that's not how I view the National Labor Relations Act in any event. I think that's an improper reading of the statute and the rights it confers. And I think the board should retreat from this extreme position.
Yes, going far beyond, of course, or outside of what Congress intended, of course, as has been stated by our witnesses already today. So for change the subject on secret ballots, for 90 years, the primary manner of exercising employee rights under the NLRA has been the opportunity to vote in NLRB-conducted secret ballot elections, which determines whether the employees have union representation. But the 2023 decision in CEMEX construction materials specific case undermines this right, despite, again, federal courts and NLRB long preferring the use of secret ballot elections to determine whether a majority of employees support union representation. Can you discuss the CEMEX case, how it undermines the NLRA?
Yes, Chairman, thank you. What has been said earlier in the witness testimony is accurate, and that is that though the decision doesn't quite doesn't quite overrule secret ballot elections, it goes a long way towards undermining them because it allows what we call card check, essentially union-promoted majorities that are really not majorities at all to be recognized by an employer under many, many circumstances. And it puts the burden on the employer to respond to a claim of union majority status when that should be tested by a genuine secret ballot election. That's extremely important when we have what I call the right to lie rule applicable to union activity in the workplace, because the unions can promote themselves in the workplace with lies, and they do frequently. And it's not that employers are blameless. In many cases, they have to be sanctioned too, but employee partisans of unions can lie, and the result of that is you have to have a secret ballot election with real campaigning to give employees information to make a fair and genuine decision on whether they want to be represented or not.
Yeah, secret balloting is a foundation of all free and fair elections, aren't they? So thank you very much. I yield the remaining amount of my time and will recognize Representative Altshuler for 5 minutes.
Thank you, Mr. Chairman. Thanks to the witnesses for coming to testify today. You've been here a long time. We've had a thorough discussion on the abuses of the National Labor Relations Board many times already this Congress, so I'm going to just jump right in. Mr. Ring, last year the NLRB issued the Joint Employer Final Rule, which upends the traditional direct and immediate control standard and creates an expansive and vastly costly, very vague standard. This past March, a federal district court struck down the rule because it exceeded NLRB's authority. The House and Senate have also passed a Congressional Review Act resolution to nullify the rule this year. Despite a federal court striking down the rule and Congress expressing its disapproval, the NLRB decided to appeal the court's decision striking down the joint employer rule. So, Mr. Ring, as a former NLRB chairman, would a bipartisan and bicameral rejection of a rule, along with a court decision knocking down the rule, would have been some of your considerations on whether or not to pursue an appeal?
Thank you for the question. I believe that we, as an NLRB member, you're supposed to stay within the confines of the statute. And if Congress, bicamerally, and with one of those chambers being the party of my party, if rejected the joint employer standard repeatedly because courts have struck down this standard before. I think that would make me rethink, go back to the drawing board and think about what the standard should be. I will say, when I was chairman, we issued in 2020 a joint employer standard that was consistent with the common law, was consistent with what courts had asked for, and has not been overturned. So I think that's, I think it's perplexing why the board continues to appeal that decision.
It looks like the board's choice to spend a considerable amount of time in these overreaching decisions that have been described by the federal courts as illogical, irrational, and nonsense have also resulted in the NLRB wasting funds and wasting time and wasting man hours. Their irrational focus on the joint employer rule has resulted in case backlogs at the NLRB that have increased to 17,682 in fiscal year 2023, an increase of approximately 8,500 since fiscal year 2020. Ms. Stock, could you discuss the board's mismanagement of the case processing and its current backlog status?
Yes, thank you very much. The Office of Inspector General issued a report in 2024 on performance-based staffing at the NLRB. The report found that despite a decline in case intake, the time to issue complaints from the filing of a charge increased. The Inspector General found that the methodology that the NLRB used to assign field staff did not meet government-wide guidance, lacked an appropriate system of internal controls, and as a result, the agency is at risk of not allocating FTEs in the field offices in a manner that would ensure that it meets its goals and objectives. So as confirmed by the OIG staffing report, the increase in case processing time and backlogs are not due to an increase in case intake, but a failure to properly manage its caseload. And the case backlog figures concern mismanagement both on the board side as well as the general counsel side. In 2019, former Chair John Ring and former General Counsel Peter Robb made reducing case backlogs a priority. And in 2019, they did reduce the case backlog. Under the current board and general counsel, the backlog started increasing immediately and reached 13,513 in fiscal 2022 when the case intake was at its lowest, one of its lowest in NLRB history.
My time's expired. Thank you so much.
Now I would like to recognize the ranking member from California for 5 minutes.
Thank you. Ms. Goldsmith, you've been representing clients in front of the board for 20 years. From your perspective, is the current Biden administration board radically changing policy, or are we just the ebb and flow of 20 years, seeing different boards from different administrations? From my perspective, and certainly I think from this side of the aisle's perspective, the previous administration, the Trump board, was the more extreme. We're just trying to get that balance I talked about in our opening statement, which, with all due respect, we can have that good debate about employer rights, balancing employee rights. From my perspective in history, given our inequality and other issues, our diminishing middle class, are we just going back through that from your perspective of 20 years of being in front of the board?
Thank you for that question. I'm sorry. Thank you for that question. In many instances where the current board has overruled decisions of the Trump board, the current board is restoring the law that had been in effect in some cases for decades before the Trump board rushed to overrule that law. By contrast, this board has been very deliberative in deciding whether or not to overrule prior decisions. So if you look at the cases where the Trump board was overruling prior decisions, they were overruling lines of authority going back in some instances to the 1940s that had been repeatedly affirmed in the courts. To take just a couple of examples, Mr. Ring has been discussing the General Motors case decided under the Trump board. That case overturned decades of board precedent going back to the 40s about situation-specific standards for when employees' alleged misconduct in the context of protected activity becomes unprotected. And the Trump board actually reached out to overrule lines of authority that had nothing to do with the facts of the case. So if you want to talk about a board that was in a hurry to overrule cases it didn't like, that was what was happening in the Trump board. The Biden board in Lyon elastomers went back to those old lines of authority that have stood the test of time in the courts. To take another example, this board recently decided a case called Stericycle about workplace rules. And it overruled a decision of the Trump board called Boeing Company, in which the Trump board actually overruled the decision of the George W. Bush board in 2004, which set the standard for evaluating when work rules would reasonably tend to chill workers' exercise of their Section 7 rights. Again, Lutheran Heritage's approach, that 2004 case, was upheld in every court to consider the matter, yet the Trump board had reached out to overrule it in Boeing. The Biden board's decision in Stericycle reinstates that standard from 2004, clarifying that rules should be evaluated from the perspective of a reasonable employee. So yeah, those are some examples of how the Biden board is resetting back to what the law had historically been.
So let's talk about the previous questions about not just the regulations, but how they're enforced. The Economic Policy Institute calculated that in 2023, there was only one full-time NLRB employee for every 90,672 workers under the board's jurisdiction. To put that in context, that is 20,000 more workers per NLRB than when Trump first took office, and 10,000 more NLRB employees when Trump lost office. So it's not just the Heritage and the Koch brothers' 30-year attack on workers' rights and the Environmental Protection Agency in terms of regulation and statutes, it's the money. So we could be more efficient. We could have that argument about how I'm a liberal libertarian, I like to say. I don't think government's a good enforcer necessarily of ethical behavior, but not funding the department also has consequences, and it empowers employers who are not ethical to and only have allegiance to the bottom line. Could you speak to your experience in terms of just efficient enforcement of the regulations?
Absolutely. It doesn't serve anyone's interests in this system for the agency to be underfunded and unable to carry out its mission. That is not good for workers, that is not good for unions, that is not good for employers. I think everyone in this system has a significant interest in the agency being able to do its job.
Thank you. I yield back.
Thank you, Mr. Saulnier. I now recognize myself for closing remarks. Today we've heard how Chairman Lauren McFerrin's tenure at the National Labor Relations Board has diminished and dismantled workers' rights and disregarded and harmed employers. As we've heard, my apologies. I'm going to let you go ahead and do your closing remarks first, Mr. Zolny. I went from your questions right to closing, so thank you.
I'm fine with either. I can be the last to speak. All right. We disagree on policy, but we don't disagree personally, which, I think the way we should work in a civilized democracy or republic. Thank you, Mr. Chairman. Thank you to our witnesses for your testimony today. Throughout American history, labor unions have served as engines of economic growth and positive change for the working class. They're human institutions, just like corporations, and they are imperfect. But They have served a very important role in the success of this country. The surge in support for unions among American people is undeniable. The workers across the nation are united to advocate for higher wages, better benefits, and safer workplaces. Under President Biden's and Chair McFerrin's leadership, the NLRB has reinstated precedent and restored balance for workers. It's not an extreme board from my perspective or from a historical perspective. These actions aim to prevent employers, or I should say unethical employers, not all employers, from infringing on workers' rights without repercussions. This is in contrast with the Trump-era NLRB, and I ask unanimous consent to enter into the record an October 2020 report from the Democratic Committee staff entitled Corruption, Conflicts, and Crisis, the NLRB's Assault on Workers' Rights under the Trump administration. This staff report outlines various anti-worker attacks by the Trump-era board. Unfortunately, this is the Help Subcommittee's 6th hearing this Congress, and the second one in less than a month, that attacks workers' rights to organize and collectively bargain. The American people deserve better. We should instead be focusing on strengthening those rights and fostering economic growth for everyone, from the bottom up and the middle out. I want to thank all the witnesses for being here, and I yield back.
Thank you. I now recognize myself again for my closing remarks and appreciate the grace of our ranking member here. Today, again, we've heard how Chairman Lauren McFerrin's tenure at the National Labor Relations Board has diminished and dismantled workers' rights and disregarded and harmed employers. As we've heard today, she holds the distinction of presiding over the most partisan NLRB in history. This board can claim all of the following dubious actions during her time. They've expanded the definition of joint employer so that more workers can fall under collective bargaining agreements, attacked independent contractor status to keep more workers classified as employees and thus able to be unionized, dismantled the right to secret ballot elections, protected harassment as appropriate behavior, and required employers to continue deducting union dues even after the expiration of a collective bargaining agreement. No doubt the courts will ultimately overturn many of these unlawful decisions, but Congress should not rely solely on the judicial branch to confront this overreach. So I hope my colleagues in the Senate will take the time to thoroughly review and consider Chair McFerrin's legacy while they determine her ability to continue her position on the board. So I want to thank again our witnesses for taking the time to travel here today and to share your expertise and to bear with us through the disrupted hearing for committee votes or floor votes. And without objection, there being no further business, this subcommittee stands adjourned.